video clip 3. The Constitutional Court goes on to say, it's at paragraph 43, that Barter Starr said or established the authority that Section 6 of PAJA had codified the common law grounds of review, and that there was this tension between PAJA, which said that your review application had to be brought within 180 days, and Section 145 of the LRA, which provided that your application had to be brought within 6 weeks. So in this regard, when looking at the difference between PAJA and the Labour Relations Act, both courts, the Supreme Court of Appeal and the Constitutional Court, they said when considering PAJA as well as the Labour Relations Act, one has to be careful of blurring the distinction between an appeal and a review. However, at paragraph 51 of the judgment, NAFSA correctly points out that the dismissal of an employee automatically raises constitutional issues, namely Section 23 of the Constitution, everyone has the right to fair labour practices, and Section 33, that your imperative of just administrative action arises because all compulsory arbitration proceedings at the CCMA constitute administrative action, and we'll see why momentarily. So NAFSA looks at the fairness of the dismissal. And with reference to Media Workers Association of South Africa versus Pascal, a 1992 appellate division, already then the court, the appellate division as it was then known, held that it was fair in the circumstances for the courts to consider both what was fair to the employee and the employer. And the court also regarded or had reference to NUMSA versus FETSAC, a 1996 appellate division decision where the court said, in considering what was fair, one had to take into account the interests of both employee and employer. And this was further galvanized in the Nahau versus UCT decision. It's a constitutional court case of 2002, where the Concord said that Section 23(1) of the Constitution says that everyone is entitled to fair labor practices, meaning that this applies equally to employee as it does to the employer. And this is where NAFSA says the SCA got it wrong, because NAMPAC as well as county fair decisions, they both use the reasonable employer test. In other words, they favor the employer. The problem with this is that the reasonable employer test is an English law principle used in English labor law, which we don't recognize as a proper test to be used. Why don't we recognize it? Because as early as 2000, the Labour Appeal Court in Toyota South Africa versus Khadebe, as well as in BMD Knitting Mills versus Saktu, a decision penned by Dennis Davis, J., said that if you want to establish fairness in a labor relations context, you have to look at what's fair to both the employee and the employer. Why? Because once again, your reference in terms of fairness is Section 23(1) of the Constitution. Everyone is entitled to fair labor practices. There's no caveat or qualification or rider that says only the employer is entitled or only the employee. And this was, it's further pointed out in the judgment with a reference to the writings of Otto Kahn Freund, who refers to the inherent imbalance of power in the employment relationship, where capital has the power and leverage against the employee. And in order to address that imbalance, we have Section 23(1) of the Constitution, as well as the Labour Relations Act, which makes provision for fairness in respect of both parties. So in this sense, the LRA and Section 23 seek to address this inherent imbalance. So whilst the decision to dismiss is within the discretion of the employer, and that in the dismissal creates the jurisdiction upon which the CCMA can now decide whether or not the dismissal was fair or not. The determination of what was fair or what was not fair remains within the discretion of the CCMA Commissioner. So at paragraph 79, NAFSA sums it up as follows, that the Commissioner has to determine whether or not the dismissal is fair. But in determining this, he or she is not allowed to consider afresh what he or she would have imposed simply because they would have decided differently. In arriving at a decision, the Commissioner must simply determine or have regard to all the relevant factors in establishing what was fair, and not merely regard or defer to the employer's decision. And then NAFSA moves on to look at the relevance of PUDGA or the LRA. And in this regard, remember the Supreme Court of Appeal found that PUDGA applies because it gives effect to Section 33. It's the national legislation. But NAFSA says that the CCMA is not a court of law. A commissioner is empowered in terms of Section 1381 to conduct an arbitration hearing expeditiously and speedily, and commissioners are, in conducting these arbitrations, are exercising public powers which impact upon parties. So at paragraph 88, NAFSA concludes that a commissioner conducting a CCMA compulsory arbitration hearing is performing an administrative function. So in this regard, NAFSA goes back to PUDGA, and having found that compulsory arbitrations at the CCMA constitute administrative action, does this mean that PUDGA automatically applies? So this takes us back to the issue of PUDGA being general legislation and the Labour Relations Act being specific legislation controlling the dismissal of employees. So NAFSA says Section 145 was the result of ongoing negotiations between capital, labour and government. And it was the outcome of these collective negotiations that gave rise to the purposefully designed dispute resolution mechanism of the LRA. And in this regard, all this SCA could find was that the only difference between the LRA and PUDGA is the time period, namely the 180 days in which you must bring your review application under PUDGA, and 6 weeks in terms of Section 145 of the LRA. But NAFSA says there's more differences between PUDGA and the LRA, and he immediately refers to the conundrum that we have, or the anomaly between subsection 1 and subsection 2 of section 157 of the LRA. And NAFSA says if PUDGA were to be applied, section 6 would not allow for exclusive jurisdiction and the fine resolution of the disputes. So in other words, it leaves room for forum shopping and negates the intention of Section 1571 of the Labour Relations Act. And so NAFSA says the powers of the Labour Court in respect of Section 158 or 145 of the Labour Relations Act are significantly different, and in fact far wider in their breadth and depth than the powers or the remedies afforded to a court in terms of Section 8 of PUDGA. So where the LRA seeks finality and effective dispute resolution, this isn't really the intention of PUDGA. And furthermore, what ultimately underscores NAFSA's reasoning is that Section 210 of the Labour Relations Act, which provides that the LRA trumps any other legislation other than the Constitution, earmarks the LRA as specialized legislation that trumps the general provisions of PAJA. So NAFSA finds that the SCA erred in deciding that PAJA applies to arbitration awards in respect of the LRA. So the first point to remember here is that the Constitutional Court is saying that although the arbitrator is performing an administrative function, once you issue an award, it's not PAJA that applies to that award. It's either Section 145 or Section 158, 1G of the LRA, which applies to that award. This is the end of clip 3. Thank you.